I just want to go over again a little bit. I learned a little bit more about some of these things because one of the lobbyists came to me and said I couldn't use the word constable. Allows constables to be able to take their firearm into the courthouse and other places that they can't now. And this is the mainstay of the magistrate judge down in Spalding County asked me to put this bill in. And so this lobbyist told me the constables were a thing of the past, that it should be marshals, and I checked. I said, I can't believe that Legislative Council would not do right on that because I know the lady real well. And so I checked with the Legislative Council, and they said constables are the ones that work with magistrates, and marshals are the ones that work with state court judges. So anyway, that cleared that point up. But it is very important to build to the and there's 4 judges in Spalding County, and I understand there's a lot of people have given objection to the amendment that was put on, and I understand Mr. Franklin wants to address that at some point. If there's any questions about this, I'd be glad to answer.
Let me ask you, Chairman Yates, is there defined in the code somewhere the word, well, let me strike that question. Are you asking this committee to delete the word constables and insert marshals, or put marshals in also?
No. Well, I mean, I really haven't thought about that because I'm just taking care of magistrate judge. But as I say, I talked to David Bundridge in council yesterday, and he said that he showed me the code section, and it's full of the word constable in connection with magistrate judges. And then he mentioned marshals in connection with state court judges.
Jill, let me put you on the spot. Is there a definition of constables in the code?
I'm not seeing a definition of the word constable, but it's used all throughout. There's over 31 references, 31 different code sections that refer to it. In Chapter 10, it's all throughout, and that's the magistrate, 1510. That's the magistrate.
So there's some legal recognition given to constables. How about marshals?
Marshals are in the code as well, yes.
Okay.
And they are different animals. So
what are marshals?
Marshals.
I'm familiar with federal marshals, but I'm not with marshals in the state system. But
marshal works in the state court.
In the state court. Okay. All right. Questions from the committee for the author, Chairman Franklin.
I have a question for you, and I'd like to recognize.
Okay. Why don't you address your question first, and let's see what the pleasure of the committee is on constables and or marshals, then before I recognize you for the other matter.
Great. In Cobb County, we have a very, very respected district attorney who ran against a district attorney that had been appointed by the then governor. And did that district attorney have to go through any criminal background check to run for office as district attorney?
Not a formal background check, although I suspect that the background check in that context would be called opposition research.
Correct, but are persons licensed under Code Section 1611-129 subjected to a substantial and very thorough criminal background check?
I'm not sure if Chairman Yates, do you know the answer to that?
Isn't it true that that is the case with the GBI and all sorts of criminal background checks for those folks?
I don't think that would really answer that question, though, these people. Are they post-certified?
They're not post-certified, but they do go through, well, to my knowledge, they're not post-certified. I'm looking at it right now, but they do have to go through GCIC and NCIC to submit fingerprints.
That answer your question?
That's for any candidate who runs and wins, or?
No, I'm sorry, I was referring to 1611-129.
Right.
You're referring to constables.
I'm referring
to 1611-129. Yes. So that's a pretty thorough check, but so someone who is licensed according to 1611-129 who is prohibited from exercising or using that license at a public gathering, we would allow a district attorney who has had no such check have a privilege and carry a firearm at a public gathering that we would not let someone who has had such a thorough check. Isn't that our current state of law now?
That is the current state of the law.
Okay, thank you. And I would like to be recognized for a motion.
And I will come back to you for that. Representative Bearden.
Question on legislative council. Right now, marshals are allowed to carry firearms, is that right?
I believe so.
I want to say they are. I just wasn't 100%
Yes.
sure when this brought up in constables, if I'm not mistaken. We're kind of out in the more rural areas.
They can carry firearms, and they do throughout the county, but not in public buildings. And
I don't think we see them much in the metro area. I think they're more in the smaller counties, and they do serve a great purpose for the courts
Right.
down in those other areas. I just want to make sure the marshals are taken care of also.
So we've established that constables and marshals are two distinct officials. Is that correct, Jill?
Yes.
And this bill simply asks us or proposes that Georgia law be amended to
include
take care
constables.
of constables, so we're not dealing with marshals at this point in time. Okay. Further questions for the author? Further questions for the author? Did anyone sign up? Yes. Yes. Okay. Was your concern with the amendment added? Okay. Can I come back to you? Okay. Sheriff Seals. Sheriff Howard Seals. Yes, Sheriff.
Thank you.
Thank you for being with us. Please identify yourself.
Howard Seals, I'm the Sheriff of Putnam County and the Vice Chairman of the Sheriff's Legislative
Daniel, would you
Committee.
slide a chair around there for?
Oh, I'm fine. I can stand up there, ladies and gentlemen. Appreciate the opportunity to talk to you. Sheriffs are generally opposed to this. I think there's a little bit of confusion here. We're of the opinion that constables are not much different than marshals. Marshals, all the state courts in the state that I'm aware of, with the exception of two, I think, were created by local acts that created those, and each one of those provides as to whether or not it has a marshal or the existing sheriff serviced that court or whatever. So those things are, one way, one county, and one way another. Constables, the only place they exist anymore, and few of the magistrate courts left in the state. A constable, if he is a certified peace officer, has the power of arrest. A marshal, if he has a certified peace officer, has the power of arrest, and they would therefore automatically be entitled to carry firearms. If these people have not been, our position is that they're not certified peace officers, if they have not had the training, the required annual training that is required of all peace officers in the state behind the use of firearms, the use of deadly force, our position is that we don't want them armed in our courthouses, no more than anybody else. It kind of flies in the face of the law passed last year about comprehensive security plans for the courthouses too. But that's our position.
Okay. Thank you, Sheriff. Representative Yates, you wanted to be
I can refer to that because yesterday I brought it out that in the past Judge Kavanaugh had a certified officer, has had certified officers, and as soon as they get certified, they go to the sheriff's department for a higher salary, and so that's one reason I think the job that they do is better to keep from having a revolving door, people going in and going out, and that was her point on that. And certainly they have a permit to carry a gun, and they're checked out like anybody else that carries a gun.
Okay. Any questions from the committee for the sheriff while we have him up here, Chairman Franklin?
I know in my courthouse there are lockers right outside the entrance that all law enforcement officers leave their firearms in those lockers. And I don't think anything, unless they are on the sheriff's staff, have firearms in our courthouse.
Well, I will say this. I think this will open legal debate here. If you have a constable that is servicing a court, then the sheriff of that county will not be the sheriff of that court. The constable would have the duties of the sheriff and the court. And I think a whole big legal debate whether or not we can restrict whether or not the constable of the magistrate court, wherever this may be, can be armed. I don't know that would be legally within our power.
Well, wouldn't, if this code, if this became law, that would make that clear, would it not?
I think it might make it clear that we don't.
Okay. Chairman Franklin, I'm sorry.
The way I read this bill, this is just exempting this from the carrying as a commission of a crime. I don't think it is giving any direction to the sheriff as to what he allows in his courthouse. This is just mean you're not committing a crime if you're a constable, and so I don't think this would direct that at all.
Representative Collins.
I want to make sure I understood this, because under the existing law, which this just adds constable too, and going on Chairman Franklin's concern about, being able to put them in the lockers as they go in, and you were saying if you add this constable, you're opening this up to a challenge. Wouldn't you currently be have a challenge right here? Because these people are already currently under this law.
These people present, the ones that are certified peace officers at present.
Right.
I don't know how many there are. I would venture to say there are not 10 constables left in the state of Georgia. But those that are certified peace officers are totally exempt from all of our firearms carry. And it makes no difference whether you're a state patrolman
right.
or constable or what it is. Okay? The difference here is if you're going to exempt these people, they're going to be out here serving processes and things like that, with a weapon. It seems they should have some sort of training other than just, go ahead and carry a weapon.
Thank you, Mr. Chairman.
Further questions for the sheriff or the author? Representative Benfield?
And I apologize for coming late, but I thought we had this bill last year with Mike Chiokas, Representative Chiokas.
No, actually, you had it, I think, with with now the governor's floor leader, Representative Cole. Representative Chokas' bill last year applied to part-time municipal judges.
Okay.
Because the law prior to last year covered full-time municipal judges, and his added part-time.
And Representative Cole had this bill last year.
Isn't that correct?
What happened last time with it? Because I remember seeing it before.
Representative Cole, you want to tell us?
Yes, we attached it as an amendment to Representative Chokas' bill.
Okay, that's why I was thinking about Chokas. Okay.
Never did any fashion with it.
Okay.
Did it pass the House?
Yes. Further questions? Any further questions? Representative? I'm sorry.
No, that's fine, because I would have just asked if we should maybe I look at all these folks, maybe we need an amendment, take away from all these fine DAs and solicitor generals here, but they may be packing, so I don't want to smart mouth. I wasn't sure.
Any further questions? Representative Abdul Salam.
Thank you, Mr. Chairman. I would like to just know on the section that talks about the retired officers, state and federal peace officers, do they have to maintain certification after they're retired?
Under the present federal statute that allows retired officers to carry weapons across state lines and things like that, the answer to that is yes.
Yes, okay.
Further questions for Sheriff Seals or for the author? Recognize Chairman Franklin.
Mr. Chairman, I move that we withdraw the committee substitute to House Bill 257 and give House Bill 257 a due pass recommendation as introduced.
Let me for people who were not in that subcommittee yesterday, for members who were not in that subcommittee, it's my understanding that an amendment was added in subcommittee yesterday that was proposed by you, Chairman Franklin, and that today you're wishing to withdraw that amendment, which would take this bill back to its original form, which would then be LC 292801S. 2581, I'm sorry. All right, you've heard the motion. Is there a second?
Second.
We have a motion that House Bill 257 in its original form without the amendment added in subcommittee yesterday, authored by Chairman Franklin, be given a due pass recommendation. Is there discussion on the motion? Is there discussion? All in favor of the motion, please indicate by raising your right hand. All opposed, please, same sign. The bill's been given a due pass recommendation, Chairman Yates.
Thank you very much, sir, and members of the committee.
Representative Benfield, your resolution, which I'd intended to call first, should be brief. Is that correct?
That's correct.
Okay. Recognize Representative Benfield on H.R. 352.
Thank you, Mr. Chairman. I apologize for not being here on time. I had to drop 2 kids off first. We've heard this issue before. This is very similar to House Bill 308 as far as the substantive issues behind eyewitness identification and why we need to work on improving those procedures here in Georgia. I finally was able to meet with the speaker. He's had a very busy schedule, and I met with him subsequent to our last hearing. And this is the advice he gave me, which I intend to follow. He said to pursue the study committee. He was supportive of the study committee, although he could not guarantee definitely that it would be approved, but he was supportive and very favorable about having a study committee on eyewitness identification procedures. And he said to hold off on the pilot project that I presented to the committee earlier last week. And he said if we want to move forward with the pilot project after the study committee meets, that we could still seek funding in the supplemental budget and come back with that next session. So that's how I intend to proceed. I'm not going to pursue House Bill 308 with the pilot project any further this session. Perhaps may pursue that next session, and the only legislation I intend to move forward on regarding eyewitness identification procedures is House Resolution 352. This is actually the only legislation I'm moving on this session, since my other bill didn't fare so well in subcommittee. That's fine. That happens. I'm happy to entertain any questions.
Questions for the author? Questions for the author?
I have a motion at the appropriate time.
I'm going to, I'm almost tempted to add an amendment to this, that the members of this who are appointed to the study committee be equipped with John Grisham's latest book to read.
The speaker did recommend that I read John Grisham's latest book, which is An Innocent Man. Is that what it's called? Yeah.
Chairman, I'm sorry, Chairman.
We all need to read that.
If I look at this correctly, we've got 9 members.
That's correct.
And, so House members would be in the minority of this study commission. Would you be agreeable to changing the 4 members of the House to 5 members of the House?
I wouldn't have an objection to that. I will say that the speaker cautioned me not to put too many people on these study committees because he's trying to hold down cost. And I told him I was currently at 9, and he was very supportive of the individuals that I had named. And just for the benefit of the folks here, we're talking about Georgia Association Chiefs of Police or designee, somebody with post, the Officer Training Council, prosecuting attorney, criminal defense lawyer, and Innocence Project, plus 4 reps. And I think it's important that we have all of those representatives from all those organizations really need to be at the table. I actually want to include the GBI as well, but we're really getting too many folks on there.
Yeah, my only concern was that at least the elected representatives of the people would not have a majority voice on that study committee. Was my only concern.
I'll honor the will of the committee. That's the only caution that was conveyed to me by the speaker, is let's not have too many folks on these study committees because then we have to control the cost. He said study committees run about $5,000 $5,000 a piece, and he said he usually approves about 20 a session, so the costs go up and up. Every person you add is more per diem. I'm just thinking about fiscal accountability, being the conservative that I am.
Your credibility is going down now.
Hey, Chairman Knox was talking about constitutional rights and due process yesterday, and I'm talking about fiscal conservatism.
Representative Goodfield, the executive director of Post, is that, you've got law enforcement?
Yes.
What was the rationale for including, if we're looking at thinning the ranks a little bit, what was your rationale for including someone from that group?
Because that's the organization that would actually be doing the training and helping to implement whatever procedures we pass, and it's important that logistically they're at the table to go through what's involved with the training.
Okay.
And that was they were recommended by several individuals to be on here.
Chairman Knox.
Since this is the primary education arm, I guess, for law enforcement in the state of Georgia is Post. Be a police officer, you have to go on Post. And I think they're supposed to be doing the major lifting on that. And so that seems to me like if we, in line with what Representative Frank was talking about, it seems to me like if we had somebody from Post plus somebody from one of the law enforcement agencies, or the GBI or whoever it is, we ought to probably have enough police input there, and the people that are actually going to be, have practical experience with the training and with the, field experience and so on. That, we probably don't need to have like everybody in their belt. If we're going to cut it somewhere, that's where I would cut it. But the major people, you'd be amenable to doing that. I mean, you don't have to increase the numbers. But
Yeah.
I think the speaker's saying hold down the number, and I agree with that. But I wouldn't want to just.
Well, if I may, for example, we have the Association of Chiefs of Police, but I didn't see the sheriffs.
The sheriffs are not down here,
Yeah.
and I've discussed this with the sheriffs, and that's fine. Again, I'm just trying to keep the numbers down. But the sheriffs, what I've learned is in the large metropolitan areas, you've got the police who are conducting the eyewitness IDs, but in a lot of the more rural jurisdictions, it's the sheriffs who are conducting these eyewitness IDs. So the sheriffs are conducting eyewitness identifications. So that would be a good suggestion. Post is educating both of them.
So it would seem to me that the fair thing would be, if we can't add the sheriffs, that we take out the chiefs of police and then deal with Post.
Or add the sheriffs, and just that would keep, but then we're having one more person outweighing the elected reps. And the speaker, he didn't give me a hard and fast number. He said, keep it around 10. So, I mean, I think we could add one more position. I just want us to be mindful of the numbers.
Chairman Franklin.
Thank you, Mr. Chairman. Something that's coming to mind is something we did in this committee on another issue that had a whole laundry list of specialized individuals on a study committee, and I'm not certain that there's anything that would keep the study committee of the members of the House from bringing in people to testify and bring input, but not necessarily would we need any of these as members of the study committee, but these would be members that could be that the 4 or however many members of the House that we would want to put on it could bring in to testify and provide input. I don't think that a study committee is limited to just its own members as far as getting input, but I think we could, whatever number we have in line 1 of page 2, they could call on the expertise of any number of people without having to pay them a per diem if they're not enumerated in here.
And that's an excellent point. I mean, I'm certainly going to make sure that Sheriff's Association and the GBI and all other interested groups are getting notices and of all the meetings, invited to attend and testify. So that's true. The advantage of actually being on the study committee in addition to the per diem, which is nice because you're giving up a day of your work. These are people with a lot of expertise, but that they have a vote in what goes into the final report.
If I could follow up, I know a lot of the heads of these organizations show up here during our 40 days to monitor legislation, and do they get per diems for that, Mr. Chairman?
I suspect there's a lot of people in this room today that are not getting a per diem.
And
They're probably getting paid more than our per diem, too, for being here today. They get a vote would be the big advantage.
Right.
Representative Setzler.
Mr. Chairman, again, I thank Representative Benefield for this concept. I would echo Chairman Franklin's remarks to the extent we had a similar study committee this past summer, which took on a broad range of issues. I'm concerned that if a member of the committee, just looking at our study committee this summer, if one of these groups who ought to vigorously advocate a position was a member of the committee, it might have, I don't know that they could vigorously advocate the position as well as they could have as being part of the group of folks speaking, advocating, frankly taking as much time talking as any member of the committee, but yet advocating a position. It would seem members of the committee ought to be more sort of at face value neutral coming into it, taking testimony of different groups. I almost think it would have inhibited certain members of our group, from the Prosecuting Attorneys Council to GAPTL to ACLU, different groups that were involved. Had they been sitting voting members of the committee, I don't know they could have advocated as strongly as they did, being part of the team but not being part of the committee.
I think then that's a good point. It becomes less of a House committee. Just an idea. How would you feel about amending on line 1 on page 2, changing the number of House members to say 5, and then deleting subsections 2, 3, 4, 5, and 6?
That's fine. If I can ask, Representative Setzler, how many members did you have? Five House members?
Yeah,
is that the typical?
I'm thinking back to last year, and I think that was the preferred number.
I wonder if there's any other changes that, I guess Jill can just let us know where else that would need to go.
What you got?
Well, if you did that on page 1, line 20, you'd say, composed of 5 members of the House of Representatives to be appointed by the Speaker of the House, one of whom shall be designated as the chairperson, period, and then you keep lining up. In other words, you're combining the paragraph, the last paragraph on page 1 with the first paragraph on page 2.
Okay.
I consider that both of those friendly amendments.
All right. Did you have your hand? Okay. Chairman Franklin?
Just a friendly amendment to that friendly amendment to get away from the political correctness. I would move that we use the correct designation from Robert's Rules of chairman, since chairman does not refer to the gender of the person occupying that office, but actually designates the one doing the chairing. So I would move that we use the standard language of chairman.
Jill, what have we been doing?
Chairperson and resolution, neutrality, gender neutrality, and all those.
I thought so.
The House does observe Robert's rules. There's a number of things that are not included.
I would prefer that we be consistent with whatever the other study committee resolutions are.
And if I might, since Chairman Cooper just walked in, I know she is designated as chairman, and I was just trying to be consistent with how we do operate.
Okay. Representative Abdul Salam. Okay. Any further questions of the author? You recognize? Yeah, let's move the amendments. See if there's any objection. You want to do that?
Speaking to Mike.
I need to be able to hear the amendment, so let's have some order.
She accepted all of them.
You want to have Jill read the amendments?
Yes, please.
Read the amendments. starting on line 18 on page 1. Now therefore be it resolved by the House of Representatives that there is created the House Study Committee on Eyewitness Identification Procedures to be composed of 5 members of the House of Representatives to be appointed by the Speaker of the House, one of whom shall be designated as the chair something, period. The
chairperson.
Okay, person shall call all of the meetings of the committee. Period.
Thank you. Move that the said amendments be adopted.
Is there a second?
Second.
Is there any objection to that amendment? Any objection? That amendment will stand adopted then. What's the pleasure of the committee on the resolution as amended?
Move to pass.
Okay. We have a motion that House Resolution 352 be given a due pass recommendation by committee sub, and there was a second. So is there discussion on that motion? Is there discussion? Hearing none, all in favor of House Resolution 352 as amended, or by committee sub, I guess now, please indicate by raising your right hand. Thank you. All opposed? Thank you very much.
I'm going to enjoy this. Maybe the last time I get a unanimous
Let the record reflect.
Measure. Thank you. Thank you.
Representative Reese, House Bill 301.
Thank you, Mr. Chairman. In esteemed committee, I bring before you today House Bill 301. This is the bill that's been kind of kicked around a little bit the last several years, but I think we got it right this time, Mr. Chairman. It's got to do with the offense of dog fighting in Georgia. And what we've done, I'm working off of LC 292791S. I think there was a little confusion this morning, but I believe we got that straightened out. Basically, sir, what this bill does is we redefine the actual definition and elaborate a little bit more on who would be guilty of dog fighting. We've increased the penalty for dog fighting, and we've actually defined dog in this bill, which is very important. On page 2, what we did was actually the reason for this substitute, Mr. Chairman, is we originally had the penalty for a spectator as a felony, and we've changed that now to a misdemeanor first offense and a misdemeanor of high and aggravated nature for the second offense. We have also got some exemptions for breeding, training. We've got a lot of support on this bill, sir. If you will bear with me, I can read the different groups that like this bill and support it. As far as I know, no one has opposed it, not to my knowledge anyway. But law enforcement, kennel clubs, dog breeders, Georgia Hunting and Fishing Federation, Heritage and Wildlife Conservation Council, Georgia Wildlife Federation, Quail Unlimited, Georgia Outdoor News, and the Georgia Canine Coalition Incorporated. That's it.
That means we don't have to hear from all of those groups today, right?
I hope they all didn't sign up to speak.
Well, we have heard from them.
Yes, sir.
All right. Y'all have heard the presentation. Chairman Franklin?
Thank you, Mr. Chairman. You mentioned a number of groups that are in support of this bill. Is there any particular group that you are carrying this bill for that has asked you to carry this as part of their legislative agenda? Or do we just have the ones that you mentioned in support of it?
Yes, sir, Mr. Chairman. Not to me directly, no, sir. I knew this is an issue. I had a little bit of personal experience, not as a dog fighter, but little bit of knowledge about this issue, and when I guess last year the bill kind of sputtered a little bit, and when I had the opportunity this year to pick it up and run with it, I did that. But no one came to me and said, you know, will you please do this from any particular group? So.
Representative Abdul Salam.
Thank you, Mr. Chairman. Excuse me, Representative.
Yes,
looking at page 2, beginning on line 30. Owning, using, breeding, training, or equipping any animal to control damage from nuisance or pest species. What if they told you that their neighbor was a nuisance?
I could relate to them for one. I'm not sure if I understand your question.
It just leaves it broad for interpretation.
Yes, ma'am.
If they sick the dog on him and the dog tore him apart, and they say, well, you know, he was a nuisance. Or she.
Well, that was not the intent of the bill to
I didn't think so.
To actually, when it says nuisance or pest species, I think you're talking about, my intention was varmints, animals, predators, you know, type of stuff, not your neighbor. But yes, sir, Mr. Chair. Oh, I'm sorry,
Chairman Knox. I'm sorry. Did that answer your question? Okay.
Well, I
think that's as good as you.
That's the first time.
I think that's as good as you're going to get.
Yeah.
Chairman Knox.
I think that you have to read that conjunctively.
Right.
That nuisance and pest refer to the same modifier there. And I think the reason is everybody's seen the ad on TV for the dog that finds termites. I guess those are what they call those. Those are pests. But you also have nuisances like moles and those kind of animals that kind of tear up your yard. So maybe we have to come and get them out. So I think a nuisance is not only a nuisance as it relates to nuisance of species or pest species. Nuisance of the species, not an individual person.
Jill, is there a more artful way of doing that? I can't think of one readily.
Mr. Chairman, if I may, if you continue with the sentence, nuisance or pest species in or around structures or agricultural operations. Structures. Mm-hmm.
I just think we need to fix it. Somebody will use that later on. But it could just say from animal nuisances or nuisances of animals or pest species.
Nuisance or pest species in or around structures.
I'm going to recognize Ms. Travis.
Could you strike nuisance or just say pest?
That leaves out rodent.
Pest is a word.
They were to me.
I don't know.
Ants and caterpillars.
I'm sorry.
Okay, good try. Vice Chairman Mumford, and then Chairman Cooper, Chairperson Cooper.
I just happen to know that we have the foremost expert on the prosecution of dogfighting cases here in the committee room with us. I want to recognize Mr. Wynn and get his view on this particular piece of legislation. He's prosecuted hundreds of these cases. How many was it, Ken? There we go.
You have any wisdom that you feel compelled to share with us? With that kind of introduction from your representative.
Just from a prosecution standpoint, Mr. Chairman, I would suggest that the language concerning subsection C, concerning knowingly aiding and abetting the exhibition, does have the potential to reduce to a misdemeanor those who are actively participating.
That's a good point. Thank you. Chairman Cooper?
Couldn't you just fix that part about species by saying it doesn't include human species?
That's what I was thinking.
Jill, be thinking on that. I had another hand, Representative Setzler and then Representative Levitas.
Mr. Chairman, I'd like to thank once again Representative Reese for bringing this. He's been very gracious, long-suffering, working with this committee on this bill. I'm going to raise to him on page 1, line 24, a question I posed, I think last week on the floor when we got to this, is a means of clarifying amendments.
I'm sorry, where were you?
I'm sorry, page 1, lines 23 and 24.
Okay, thank you.
Where it says, for amusement or pain, causes any dog to fight with another dog or causes any dogs to injure each other, would it be appropriate to insert in an exhibition of fighting with another dog? Or is the public policy purpose here to include, let's say I've got a dog in my yard and I see someone walking their dog down the street and I would sick my dog on their dog for amusement. Let's say I'm just a sicko. Or let's just hypothetically.
Okay.
You better hurry and finish. I've got people wanting to make motions now.
Well deserved. I guess it's a public policy question. Is your bill seeking to address someone in a non-dog fighting environment sicking a dog on another dog with respect to the same felony treatments, or would what I've described to you be outside the intent of the bill?
Representative Setzler, I believe that's a great question. I really believe this bill is targeted to the I hate to use the word professional, but the dog fighters groups that actually get involved with a lot of other things. But I would also think that if someone was in a neighborhood that had a dog that they, for amusement or gain, continually cause that dog to fight with other dogs or injure other dogs, should be also guilty and punished for doing that. So I believe that's why the sentence was in there. It's not the casual dog fight of someone walking down the street. I would like to think someone would not be overzealous and try to punish them under this code or under this bill. But if somebody was, like you said, a sicko, whoever we're talking about there, that continually did this, I would say they would need to also fall under this bill, under this punishment. So.
I'm just asking. Certainly, the person that's sick, walking through the neighborhood, someone who's sick, one dog on another dog ought to be punished. I'm just asking if that ought to be a felony offense.
Right.
That's consistent. If that's consistent with this, I'm not clear that I would view that as a traditional felony. But that would seem to fall under the purview of this bill unless we said otherwise.
You want to respond before I recognize the next representative?
Yes, sir, Mr. Chairman, I would. I think the term for amusement or gain, if you look at a whole sentence, and I know we all are very good at looking at particular pieces of a sentence, I guess, but for amusement or gain causes any dog to fight with another dog or causes any dogs to injure each other. And I was also counseled too that a judge hearing this, say if someone was in a neighborhood that 2 or 3 times had a dog that just out of pure meanness or amusement would cause their dog to attack another dog and cause injury. I don't know. I think the judge has, and again, I'm not trying to be a judge. This is just from counsel I've gotten from some esteemed attorneys. That the judge would not have to penalize them, and hopefully it'd be a case-by-case thing. But we did want to kind of try to cover someone who may just for amusement, whether it be sick amusement or whatever, I would have to say it would have to be, but just just out of meanness, I guess, amusement to them, that had dogs that attacked other dogs. I mean, it's. I know. Actually, we had that happen personally to me, and this is not the reason I dropped the bill. Actually, I had forgotten about it, but years ago, we had a little poodle dog, and 4 dogs jumped on it and just tore it to shreds. And it cost a lot of money to patch that dog back together, and basically the woman got off scot-free. But it's.
And I was just asking that if that should be treated as a felony, as would be consistent with this bill, and if there ought to be some other carve out, make sure we're talking about just exhibition.
I do remember us talking about that too, and I do apologize. We did talk about a little change of verbiage on that the other day, and honestly, I just forgot about that. So
that take care of you, Representative Levitas.
Thank you, Mr. Chairman. Mr. Chairman, may I be permitted to follow up with Mr. Wynn?
If he wants to subject himself to that.
Friendly question. Would it fix the concerns that you raised if we put in I'm on page 2 at line 10, beginning any person who is knowingly present, if we inserted the word only as a spectator and struck the language that says or who knowingly aids or abets in another such exhibition, because it sounds to me like what you're saying is general criminal law would cover somebody who's aiding and abetting, and that way there wouldn't be any question about whether it got subsumed into a misdemeanor, and then anybody who's merely a spectator would not be folded into the felony language. Would that address your concerns? All right, then at the appropriate time, Mr. Chairman, I'd have a motion in that regard.
Nope. Any further questions? This is why I'm so proud of this committee. You know, if y'all want to be encouraged, the Senate has sent over a bill on the same topic that I think they must have spent about 5 minutes on. So we have that to look forward to. It's also why folks ought to do like Representative Oliver and me and own basset hounds. You wouldn't have this problem. Any further questions of the author? Any further questions? Who wanted to be recognized? Did you?
I'll be recognized.
Okay. Vice Chairman Mumford.
Representative Reese, I've got what I hope is a friendly amendment. On line 23, where you've got for amusement or gain causes any dog to fight with another dog, and then it says or causes any dog to injure each other. I'm pretty sure that you meant that it would be for amusement or gain. I mean, obviously people might be walking their dogs and somebody's dog jump on somebody else's dog. Mm-hmm. Would you object to putting in a clause and have it read, for amusement or gain causes any dog to fight with another dog, or for amusement or gain causes any dog to injure each other? Just to make it clear that both of those are for amusement or gain.
No, sir, I would not have an objection to that amendment.
I think Representative Levitas had his hand up next, and you're recognized.
Would this be the appropriate time for motion, Mr. Chairman? I would move that we amend on page 2, beginning at line 10, in between the word present and as, we insert the word only. On line 11, beginning with the word or and continuing to the word shall, strike all words from or through shall.
Yeah, could I hear that one
And so
more
it
time?
would read now, if the committee accepted the amendment.
Beginning at the beginning of line 10.
Yes, sir. The new subsection C would read, any person who is knowingly present only as a spectator at any place for an exhibition of the fighting of dogs upon a first conviction, and then it continues on, be guilty of a misdemeanor. And through the rest of that sentence. Oh, you're right. You're right. Absolutely right. I've got a not strike exhibition, but not strike shall. So that would read or. So I'd like to amend my motion to say or, strike from or through exhibition, and leave in that shall.
Mr. Wynn, as the leading authority in the state, does that take care of the issue you raised, you think? Okay, thank you, sir. Chairman Knox.
While we still have Mr. Wynn's attention, what about age or events in line 2 of that paragraph on page 2 at the end of the sentence? Is that also a problem?
It's not a problem because that is undeveloped, so that's not a problem.
Okay.
Further comments? Representative Setzler.
Sure, again, we offer on page 1, lines 23 and 24, for amusement or gain, cause any dog to fight with another dog, or as Vice Chairman Wilson said, for amusement or gain, cause any dogs to injure each other, I would offer, as a friendly amendment, in an exhibition of fighting with another dog. And it's, we often consider, again, clarify the felony treatment of the first offense.
So your suggestion is to add language on line 24 after
To injure each other, I would add, in an exhibition of fighting with another dog. I'm trying to mirror, I'm trying to mirror the language on line 22. It talks about owns, possessions, trains, transports, or sells his dog with intent such dog shall be again in an exhibition of fighting with another dog. I'm simply suggesting we insert for the author on line 24 in an exhibition of fighting with another dog.
I'm fine with that, Mr. Chairman. I think it's good language.
You have heard, and none of these have been in the form of a motion yet, and I'll come back to that. Chairman Franklin.
Thank you, Mr. Chairman. To Representative Reese, but if we adopt that, then that would pretty much make this paragraph 2 meaningless, since it would be right there with paragraph 1. But isn't it true that one form of training these fighting dogs is this behavior that you originally intended to cover, where the little poodle is walking down the street and you sick your dog on them to get them kind of accustomed to attacking other dogs and such? And
well, actually, the procedure is to kidnap Fluffy and bring Fluffy back and throw it in the pen with the other dogs to give them the taste of blood and an easy victim to devour. And you're exactly right.
And so I would say, based on that, wouldn't we need to keep this paragraph 2 intact, other than the Mumford Amendment for clarification?
Why don't I draw Jill into the conversation here?
Yeah.
I was going to wait and sort of let you take a swing at all these proposals.
I think if I agree with Chairman Franklin that if actually you're trying to make this applicable to only exhibitions involving dog fighting, that you would move that clause all the way up to line 20 so that it would apply across the board. But if the scenario that Chairman Franklin described was in fact what you were trying to prevent, the language on lines 23 and 24 with the addition that Vice Chairman Mumford added would cover it.
Okay.
I mean, I can withdraw that. I'm not looking to, I wanted to have the discussion. I think it's something we can consider.
Sure.
There are, as I understand, misdemeanor charges are broken down that might apply better. I'm just conscious of anyone whose dog gets mauled is going to go and double bucketeers and courtrooms. If someone's subject to felony treatment, it would really be almost, I'm just concerned of overexposing folks. I'll withdraw that.
Okay, thank you. Okay, you all have heard the discussion about proposed amendments. You've heard the comments of Ms. Travis. Any further questions or discussion about the bill? You want to offer that? Okay.
Yeah, you're taking my neighbor out of the picture.
You know, we have a history with dogs, okay? But Representative Cooper actually stated exactly what I was trying to say, so we could just say, from nuisance or pest species.
Where are you? Where are you?
We're on page 2,
Line 30.
31.
Okay. And
Just simply insert after species, other than humans. The gentleman will accept that.
May I be heard a minute?
Vice Chairman Mumford.
Maybe I'm misunderstanding what the intent of the amendment is, but it looks to me like section 5 down there on, or I guess it's paragraph 5. Owning, using, breeding, training, or equipping any animal to control damage from a nuisance or pest species in around structures or agricultural operations. Nuisance or pest species are obviously termites, rodents, and this is carving out an exception for those. And I don't think. I mean, I don't know where we're going. It's almost kind of insulting to think that a human being is in the same category as a nuisance or pest species. And there are other protections for human beings that this bill probably doesn't need to reach. I mean, if you sick a dog on a human, you probably got a lot of other criminal problems. But, yes, ma'am.
You know history, and you know that has been done.
Well, if I understand it correctly, this is carving out exceptions to this law that are protected exceptions. Well, if that's the concern, then maybe the amendment ought to be up in line 3 regarding training and equipping dogs for law enforcement purposes. I just don't think that it's...
Mr. Chairman, may I?
Let me recognize Chairman Knox.
I think we're missing the point of the sentence. The issue is the damage, not the species or the nuisance, either one. This is, and the reason for that is, as I suggested earlier, what you're trying to get at is the dogs that are used to find where termites are, where moles are, and that sort of thing. This is saying only using, breeding, or training, or equipping any animal to control damage or nuisance, not to control the nuisance or to control the pest species, is to control damage. They're supposed to find out where the damage is. They don't eat the termites, they don't eat the moles. They just find out where they are, what it is, and then you're supposed to go in there and dig them with a shovel or spray them with a chemical or whatever. So this whole sentence is the whole subject of this sentence is the damage control, not the animals, not the species, not the whatever. Well, they can, but it still wouldn't allow you to stick them on. If a human being is doing something to the foundation of your house, I guess, and you have a dog who's breaking bread to find out what that damage is, then this would allow them to do that. But it doesn't allow them to sick the dog on the person who's doing damage, other than you would if somebody comes in your house, you got a dog in your yard, and the dog goes after him. There's nothing wrong with that.
Mr. Chair, if I may, I'll withdraw.
Okay, thank you. All right. The chair is ready for motions on any proposed amendments. You've heard some discussed, some withdrawn. What's the pleasure of the committee? Well, it wasn't. You want to restate it? Representative Levitas.
Mr. Chairman, I would move that we amend Section 1 on page 2 at line 10, Section C, as follows, by inserting the word only on line 10 between the words present and as, and on line 11, striking the words or through exhibition. The provisions of line 10 and 11 would then read, C, any person who is knowingly present only as a spectator at any place for an exhibition of the fighting of dogs shall, upon first conviction, and then it continues on through the rest of that paragraph.
Okay. All right, you have a motion to adopt the Levitas amendment. You've heard it stated. Any question about the Levitas amendment? Is there any objection to the Levitas amendment? Hearing none, that amendment is adopted. Did you want to be working on page 1?
Yes, on, I'll make the motion to amend at line 23, on page 1, to insert the words so that the sentence would read, for amusement or gain causes any dog to fight with another dog, or for amusement or gain causes any dog to injure each other.
That's in the form of a motion?
Yes.
All right, we have a motion that the Mumford amendment as stated be adopted. Is there any question about the Mumford amendment? Hearing none, is there any objection to the Mumford amendment? Hearing no objection, the Mumford amendment is adopted. Further questions or discussion? Further questions or discussion? What's the pleasure of the committee?
Have a motion at appropriate time.
Vice Chairman Mumford.
Move do pass as amended.
By committee sub as amended. Okay. Was there a second? Second. We have a motion that House Bill 301 be given a favorable recommendation to the Rules Committee by committee sub as amended. Is there any discussion on the motion? Any discussion on the motion? Hearing none, all in favor, please indicate by raising your right hand. All opposed? The bill has been approved, Representative Reese.
Thank you, Mr. Chairman. I appreciate that very much.
Good luck, Representative Reese.
Yes, sir.
Chairman Oliver still around? She waited around. I wanted to take her little bill next, and then we'll take up Representative Fleming. Is that okay with you, Mr. Whip? Okay. If you'll just be on deck. Come around, Madam Chairman.
Thank you, Mr. Chair.
Madam Chair, I thought you were in here earlier and I used your name, and since I talked behind your back, I thought I better tell you what I said.
Okay.
We've had a long discussion about a dog fighting bill. I said, for people that own basset hounds like you and I,
right,
this is not a concern.
Not a concern. Getting off the couch
is a concern.
Out of the house.
Is a concern, but not fighting. Could I have some order, please? I got something very important to take care of here with this bill. Can we please shut the door? Can we have some order, please? I understand, Madam Chair, today is a special day.
Oh, Lord, no.
Not only are we taking up House Bill 662, but it's your birthday.
It is my birthday.
Would the members of this committee join me in wishing Chairman Oliver a happy birthday?
Thank you. Thank you very much. Thank you, Mr. Chairman. Thank you. Birthdays are a little unnerving at certain...
I understand. I can relate well.
Just be glad he didn't ask us to sing.
I'm very grateful.
I expect a lot out of this committee. Singing is not something I expect out of them. Tell us about House Bill 662.
Well, I have one request for my birthday, Mr. Chair.
A do pass recommendation.
Since you brought it up,
I thought if we were just extremely nice to you, maybe that we could get by without doing that.
Always pushing a little bit. Mr. Chairman, I bring to you substitute 2803, LC 292803, based on the good work of the subcommittee yesterday. A bill to help the state of Georgia manage the issue that it has to manage in relation to federal dollars about how you detain status offenders under the federal ODGJP Act and under the State Juvenile Court Act. We are, as you also know, Mr. Chair, we in Georgia are under a federal MOU, Memorandum of Understanding with the federal government in relation to certain federal funds for juvenile justice issues, and how we maintain status offenders is part of the overlay that we have to be conscious of. I have had the cooperative assistance of DJJ and the Council of Juvenile Court Judges and the Criminal Justice Coordinating Council, and they have, each amendment they have brought to me, I have adopted into this draft, and I've got two other suggestions this morning that they requested that I consider to be friendly amendments, and I'm going to ask the committee to consider. It's a little bit of a confusing issue. If you pick up a child for a status offender, that is a curfew violation, that's a runaway, that's a truancy, that's a child committing an offense that is not a criminal act if that child was an adult, but is an offense under the unruly definition of juvenile code. If you pick that child up under Georgia law and federal law, you are not allowed to put him in jail, period. Despite that, and there's a lot of detail there, and I'll tell you is how much you'd like to hear about that, there's a lot of detail about what jail secured detention is as opposed to non-secure detention. But despite that requirement of law, DJJ has shared with me that they are incarcerating in secure detention facilities over 1,000 children a year based on their most recent status offense. They believe that that is a problem in terms of what the law intends and in terms of how we manage our resources. We really can't afford to be putting in jail a child who's a runaway or a curfew violator for any period of time beyond the 24 hours, 48 hours, 72 hours that's set forth in this federal overlay. So I bring to you 662 to clarify and coordinate and make sure that the state of Georgia is in compliance so that sheriffs aren't doing what parents should be doing, that is babysitting their children. I understand the frustration of a parent who says, I'm tired of him, you take him. But I'm afraid that neither the state law, the law, nor what we intend is that the state law puts a child in a secure detention for a truancy, a curfew violation, a runaway. So, Section 1 simply clarifies in deletion of that paragraph at the top of page 2 that we're going to deal with the existing state law of supervision in Section 2. In Section 2, we are tracking, in essence, what the federal law requires. And that is that if you are going to securely detain a child for a status offense, who is a pure status offense, they've not committed a delinquent act, they've not committed an act of violence, they've not violated an existing court order, then you can only do it. You really can't do it for longer than 24 hours, with one exception, and that's the amendment that the Council of Juvenile Court Judges have asked me to suggest, that at the end of line, I have this prepared for you, Mr. Chair, line 23 on page 2, we add the language, and now I gave you away a copy so I can't read it, except I had made some copies in there, except a child alleged to be a runaway pursuant to OCGA 1511-212D shall be detained only for as long as required to effect the child's return home, but not later than 24 hours. Under the federal law and under the state law, you also have, the juvenile court also has an option of doing what's called a dispositional hearing, adjudicatory, to determine if the child committed this offense, if the child violated an act and violated an existing court order, then you might be able to detain him longer. So, the other amendment I'm asking, this is at the request of DJJ, is to insert the word on page 3, line 4, and page 3, line 11, to insert the word may instead of shall. DJJ is a little concerned about the mechanics of those, and this is a few number of cases that they actually have a dispositional hearing for a status offender within the first 72 hours.
I'm sorry, where was the second place?
I apologize. It is on page 4, line 3, and on 4, line 11. I apologize. I'm happy to answer questions, and I'm happy to go through in any detail that the chair would like me to do about this 24, 48, 72-hour business.
Okay. Thank you very much. Chairman Franklin?
Thank you, Mr. Chairman. And if I read the bill correctly and understand your presentation, what this bill is doing is actually asking the parents to actually be the parents?
Yes, sir. That's a fair interpretation.
Wow, and that is so rare around here, and I thank you for it. Thank you.
Well, I believe the federal law and the state law requires us to do that, and despite that, we are incarcerating pure status offenders, over 1,000 of them a year, in beds that we're paying a lot of money for.
How much are those beds now?
Between $30 and $200 a day. Is that a fair range?
DJJ, are y'all here? Cost of the beds? Cost of the beds? Okay. Representative Setzler?
Mr. Chairman, I apologize. My microphone's not working over here. I'll have to speak up. I'm reading page 1 of line 25, just a clarification for me. I apologize. Possession of alcohol and beverages is a status offense?
No, sir, I don't think it is. It's a possession outside your home, I think, is a criminal act. Possession in your home is not, if I'm remembering that correctly. But I don't know the legislative history of that existing law right there, but it looks like it's saying to the police officer that you can treat a minor hanging around a bar as a status offender, although I believe if he had a beer can in his hand out in the public, he'd also be guilty of a misdemeanor. This is existing law.
I was, as I read section 1, I was, am I to understand that this definition, unruly child, that's the definition of a status offense?
Yes, sir.
So as I read this, possession of alcohol and beverages is a status offense?
Yes, sir. In addition to being a misdemeanor. It could be either, as I understand this existing law.
Mr. Chairman, if I could just kind of unpack this for a second. So the status offense, again, is the case in which it's only a criminal act. It's only a... It would not be a criminal act if it was done by an adult. I read this, again, I'm wanting to make sure kids in minor possession of alcohol are included in this protection, and I'm not clear from what you said before, but also being a misdemeanor, that would be the case.
I believe possession of alcohol by a minor is a misdemeanor. Am I correct?
And that's different? Handled different?
No. If a child commits a delinquent act, if a child commits a criminal act, misdemeanor or felony, then they're treated as a delinquent, and the way they're detained is treated differently. My bill is only about detention. But you raised a good point, and I had noticed this in the existing law. It seems like if the statute's a little bit duplicative in that a child could be creating both a criminal act and be alleged to be an unruly child under the juvenile code.
So, from a public policy standpoint, I want to know where your stance is. I think I know what my stance is.
I have not addressed this in my bill, but my personal opinion is that possession of alcohol is a criminal offense for a minor. It's not an unruly status offense. That's my personal opinion. I don't know what the history is that that's included there, but if I were the police officer, I would treat it as a criminal offense and not a status offense. Sir?
Sure.
Because this would also seem to extend, and again, I'm way out there, a little beyond my understanding of the details of law. I understand there's a provision in law that deals with juveniles driving and have a blood alcohol content that's below the DUI threshold, but yet it's above the .02.
Yes, sir.
Am I to understand that's not a status offense?
That would not be a status offense. That would be a delinquent offense. You know, juvenile courts have jurisdiction over children who are deprived, neglect, and abused. unruly, status offense, or delinquent, they've committed some criminal act. What you're talking about, driving with any alcohol content for a minor, or possession of beer outside the bar, are misdemeanor offenses, designating them as delinquent children under the juvenile court jurisdiction.
I guess my question can be crystallized around why is that not a status offense?
Because it's a criminal act. And runaway is not a criminal act if you're 18 years old.
Is runaway a criminal act if you're 16?
Yes, sir. No, it's a status offense act.
I'm just trying to understand, I mean, if kind of the definition of status offense is that which is not a criminal act if committed by an adult, but if done by a child based on their age it is, particularly with possession of alcohol listed here in subsection G. I'm not sure why that is.
I'm not sure either, based on the history. If you wanted to take that out and add that as a different policy statement for the state of Georgia, I certainly would have no objection. My focus is on detention of status offenders.
Would this be the appropriate vehicle to do that?
Do you have an opinion? To the author?
I have no objection if the chair would like to entertain that.
Be thinking about an amendment, Representative Sessler, if that's what you want to offer at the appropriate time.
Is it your policy that's a criminal offense and not a status offense?
I guess I tend to be of the belief it's a status offense. And I don't know. I'm going on some looking at a couple states. I don't know.
Then it would not need to be amended.
If you want it to be a status offense, you would leave it here.
Yep. Representative Levitas.
Thank you for being here, and I appreciate this bill. I have what I think is a very friendly amendment and just a question about that same section. This is on the handwritten amendments. At the bottom there where it says not later, I think that ought to read no longer rather than not later.
Yes, sir, it does. Thank you, that's
okay.
correct.
And then my only question is there a provision either in existing juvenile law or would it offend what you're trying to do if, under extraordinary circumstances, if parent is in California or some other place and can't get to the runaway? My only concern is if we can only hold them for 24 hours and they dump them back on the street and parent, for whatever reason, hasn't been able to get there. Is there any kind of exception already existing in law?
There are a couple of different exceptions as a practical matter. One is if the child has committed another delinquent offense or is in violation of an existing order, then they can be held longer. Secondly, some of these runaways, some percentage of them are already in the custody of the state of Georgia. They're DFACS children. And there's a cooperative agreement today between DJJ and DFACS about transferring a child from DJJ to DFACS facility. Thirdly, you can hold a child in any non-secure facility. Now, there's a variety of different non-secure facilities available to DJJ, and this only deals, my focus is only on secure hard beds. You can also hold a child in a group home, a shelter, things where there's hands-on, watchful supervision, but not a cell. So I believe that your amendment would be violative of the federal law if you said extended for runaways, although as a practical matter they are keeping runaways beyond the 24 hours or beyond the time it takes the parent to come, if the parent will come get him.
Right, and that I guess was
another issue.
My concern. But it's not an amendment form of a question. You've answered it that we're covered. I just didn't want to be in a position of releasing a runaway before a parent could get to him or her. But the only motion that we'll have at the appropriate time is just to change that from not later to no longer.
I'll come back to you for that. Representative Abdul Salam.
Representative, thank you so much for this bill. My juvenile judge is very pleased. You know, at the National Juvenile Justice Conference last year, Bart Lubow talked about this happening across the country, the status offenses, and how many more thousands are being held in other states. And I think that his analogy was very good. He said usually when we hold those kids for status offenses, it's because of POAs. And so everybody was going to POA, pissed off adults. Right. You didn't do what I told you. You talked back. You slammed out of the room. Didn't get home on time. And so I think this is very reasonable. I wanted to ask you, though, right now in our system, about how long are they holding the status offenders, the average?
Well, those 1,000 children, I think, are, if my figure's correct, I see the data guide there, it's about 20 days.
Okay.
And if I'm wrong about that, I invite him. That's what my memory tells me.
Okay.
And that's an average, is that right,
Doug
sir?
Engel, Department of Juvenile Justice. It's 2006. It was 15 days.
Okay.
Average.
Thank you,
All
sir.
right, thank you.
So that's 14 days times $200 times 1,000.
Thank you.
Further questions from the committee? Further questions from the committee? Recognize Representative Levitas for an amendment.
Mr. Chairman, I would move to amend the amendment that's pending before the committee. This is the handwritten sheet that Representative Oliver presented us. In the paragraph that refers to page 2 at line 23, I would just request that we change the words "not later" to "no longer." That would be my motion.
Page 2.
This is on the handwritten sheet.
Oh, I'm sorry. Okay.
It's really an amendment to the amendment being offered. But
Okay.
I think it's a friendly one.
All right, would you repeat that, please?
On the first paragraph that refers to page 2, line 23 of the bill, and it inserts certain language at the bottom line of that first paragraph where it reads "not later than 24 hours," I would just request that it read, or I would move that it read "no longer than 24 hours." And I believe that's one that the officer would go do as well.
Yes, sir.
Yes, Joe.
There's some, can I clean up this?
Please do.
handwritten one?
Please do.
It should say, I'm reading from the handwritten one, it should say, except a child alleged to be an unruly child in violation of subparagraph 12D of Code Section 15-11-12 shall be detained only as long as is required to effect the child's return home or to his or her place of abode.
What you're
No longer than 24 hours.
and what you're doing is taking out the you're using the existing language. Is that what you're doing?
Yeah.
And that's what that was my intent too. There is an existing exception for runaways, and I'm trying to move it into that. And so Jill found the exact language.
Anything else?
That's what
Did that include all of the handwritten? Okay. Does everyone understand Legislative Council's cleanup of the proposed handwritten amendment, which has been moved by Representative Levitas? Any questions? Did somebody second that?
Mr. Chairman, would it be appropriate
Okay.
to adopt what she's doing as part of my amendment, just for the purposes of getting it before the committee?
Your motion was to amend the amendment. The amendment has now been amended. So why don't I will recognize you to make a motion that will incorporate all of that into one.
So moved, Mr. Chairman.
Any questions? Thank you. We have a motion to adopt the Levitas amendment. Does everyone understand the Levitas amendment? Any questions? Is there any objection to that motion? Hearing none, the Levitas amendment is adopted. Any further discussion, questions from the committee? What's the pleasure of the committee? Madam Chairman Cooper. Motion by Chairman Cooper. Did I hear a second? And a second. That House Bill 662 be given a due pass recommendation by committee sub as amended. Any discussion on the motion? Chairman Franklin.
Did we include the remainder of the handwritten amendment with the Levitas amendment? Because I think
My
he was
intent
just.
was, yes.
Thank you.
Ms. Travis cleaned up the upper portion of it. Any discussion on the amendment, Jill?
Well, the handwritten, I think the handwritten amendment doesn't fully reflect everything that Representative Oliver said. The changes are on page 3, line 4, changing shall may
You're exactly right.
And page 11, line 11, page 4, changing shall to may.
What is the page 3?
I think, was there one on 3?
No.
Yeah, that's.
I think that was an error.
That's correct. There are 3 places. I'm sorry, Mr. Chairman. There are 3 places where the shall should turn to may. I'm sorry.
So three
Abstain.
Recognize Chairman Cooper to withdraw her motion. Do pass. Did everyone get the 3 places where we're changing the word shall to may?
Mr. Chairman, I had made the motion at the exact same time.
Okay. I'm looking for a motion to move the amendment now. Okay. Is there a second? All right. Does everyone understand the Abdul Salam amendment? Is there any objection? Hearing none, it is adopted. Now, Chairman Cooper, we have a motion now that House Bill 662 be given a due pass recommendation by committee sub as amended. Is there any discussion on the motion? Any discussion? Hearing none, all in favor, please indicate by raising your right hand. All opposed, same sign.
Thank you.
Happy birthday.
Thank you. And I'm glad to know I'm more conservative on liquor than
What's the pleasure of the committee? Would y'all like about a 5-minute break before we take the next bill? We're going to be in recess for 5 minutes, and then we'll have Representative Fleming. Could we have some order, please? Could we have a little order, please? We have the concessionaire walking through the aisles selling sandwiches. I thought I was at Turner Field there for a moment. Okay, Chair now will recognize the Majority Whip of the House, Representative Fleming, on House Bill 197. Thank you for being with us, Representative Fleming.
Mr. Chairman, thank you for allowing me to come today. I bring to you in the committee today House Bill 197, which passed unanimously out of subcommittee yesterday with bipartisan support. The bill eliminates the Senate's Review Panel. The Senate's Review Panel was an entity created almost 30 years ago in the state of Georgia to review sentences where persons received more than 12 years in prison. They were empowered with the ability to reduce those sentences. The reason that I brought this bill to you today is to try to solve some problems with that. And basically the bill eliminates that Senate's Review Panel.
I think it might be from the door. Can you maybe speak in the microphone?
Certainly. I'm sorry. The purpose of bringing the bill to you today is to try to solve some problems that have been created by that panel. The first problem is the question of constitutionality. Is this 3-judge panel constitutional? Because of the fact you can make the argument that it interferes with the separation of powers. How can we as a legislature create an entity that can overturn the actions of a court? That is currently the question has been sent up to the Georgia Supreme Court. They've sent it back to a trial court here in Fulton County for remand. And I think in the language of their remanding the bill, invited us to do something about the problem. The other problem that has arisen in recent years regarding this is that the 3-judge panel has actually overturned plea bargain agreements. Plea bargain agreement, as you know, is when the DA, the victims involved, the defense attorney, and the defendant come together and decide they will accept a plea bargain of guilt, and for a certain amount of years. There actually have been instances, and you'll have some district attorneys which will testify to you this morning, of how plea bargain agreements have actually been overturned by this panel. The other part that the bill attempts to solve, a problem with this 3-judge panel, is it is somewhat duplicative of other parts of the system. We have a parole board that's set up much better to deal with these issues. We also have appellate courts that deal with these issues. The way this three-judge panel operates, it's somewhat, you could say, behind closed doors. It's not open to the public. Victims of crime are not allowed to come testify and give their part of why a certain sentence should not be reduced. Mr. Chairman, that is basically what the bill does. It's relatively simple in its scope. There was a good bit of discussion yesterday in subcommittee, and I'd like to thank Chairman Knox for allowing us to perfect the bill in subcommittee yesterday that didn't deal with whether or not we should eliminate the panel. It dealt solely with how we wind it down and what dates were needed for the stuff in the pipeline already to be heard and to be finished without creating any problems. And along those lines, Mr. Chairman, our judge of the day yesterday was Judge Osborne, who is still with us today. He didn't make one note to me of one date that probably needed to be adjusted, and I don't have a problem with that. I've already discussed it with the prosecutors. That is on page 3 of the bill under section 2, line 29. There's a date there that says November the 1st, 2007, and he's asked for that to be 2008, and that was simply for to allow what was in the pipeline to already go through and to let these cases be wrapped up. And I don't have a problem with that at the appropriate time if we amend it and change it to 2008 per Judge Osborne's request.
Thank you, Representative Fleming. First, let's do it this way. Questions from the committee to Representative Fleming. Representative Benfield.
Thank you. First question is the Georgia Supreme Court decision you referred to.
Yes.
Do you have a copy of that or a site?
I do not have it with me, but some of the district attorneys who will testify later can tell you that.
Okay. I would like to see the remand. You said there was a decision printed, and then they remanded it to the lower court, and that's
they remanded
pending?
it for the question of whether or not this is constitutional, is my understanding, and allow the lower court to address that.
Okay.
Yeah.
If I may ask I've got a couple of questions. The overturned plea agreements.
Yes.
How often does that occur, and do you know any of the specifics? Were these cases where perhaps there wasn't adequate counsel to it? I mean, were there some compelling constitutional issues?
You raise an interesting question.
In those circumstances, because
you raise an interesting question. We don't know the answer to that because this panel acts behind closed doors. Many of those facts aren't known as to why they do what they do and when they do it. However, I would say to you that any plea bargain agreement that's overturned is one too many. And once again, there'll be some district attorneys who will testify today who can give you specifics, as they did in subcommittee, as to when this has happened.
Well, certainly you would agree. I've done habeases in some plea cases, very rarely, but there are some circumstances where perhaps the defendant is not mentally competent or there's not adequate counsel where it is appropriate to overturn a plea. But I agree this is not the proper...
All of which can be handled by the appellate courts.
This is not the proper
yes.
Jurisdiction or venue for
yes.
that. And then my final question, this is the larger issue, is, and I've petitioned cases to the sentence review panel, and I think there are a lot of issues that do need to be addressed. But just initially, this is the first time I've considered this bill, so I haven't given a lot of thought, but my initial reaction is not to throw out the entire system, but to tweak it. Perhaps not say you can overturn plea agreements, and that the process, I've always thought the process should have been open, and I've had concerns about that. But I've seen problems where there are some jurisdictions that are imposing much lighter sentences for the same crime. You might see in Fulton County a burglary will get a lot lighter sentence than in Hayhira, Georgia. And that was what I liked about the sentence review panel, is that they looked statewide at how sentences are being handed down for similar crimes with similar facts, and did have the authority to lower the sentence in some cases. And the parole board and appeals, those are other means to pursue redress, but they don't have the power to reduce a sentence, and so that was what the sentence review panel did. So my question for you is, how are we going to evaluate in the criminal justice system inconsistent sentences being handed down in different jurisdictions if we do away with the sentence review process?
The point you make is a double-edged sword, because of the fact you're saying that in some instances things may need to be adjusted and someone needs to review that. My argument to you I would make is, who is better to review that than the judge and the jury that heard that at the trial level? And this panel that is set up hears the matter cold. The victims can't come before them and say why something shouldn't be changed. All the prosecutors can do is, if they know when it's going to occur, send in a memo asking, for consideration for certain facts. And so if you want to address a better way to deal with that, I'll be welcome to talk to you about that. But the only thing that I'm sure about in this instance is that this system is absolutely not the correct way to do it.
If just one follow-up, but my concern is this, that there's, without this, and this is not a perfect system, but without this, there's no statewide review. And I understand what you're saying. You go back to the judge, but I'm looking at somebody, some entity that can look at inconsistent sentences being handed down throughout the state.
There is a statewide review, and that's the appellate court and the parole system, and also this legislature is a statewide review. If there's a better system that you want to put forward, I'll be welcome for you to bring the bill. But all I know is that this particular system is very broke, and we need to eliminate what has been an injustice for quite some time.
Representative Beard.
Thanks for bringing this forward. Since we're talking about review, and my question would be, who will review the inconsistencies of the three-judge panel? No one can review them, can they?
That's correct.
Thank you.
Chairman Franklin.
Isn't it true that so often we hear that we don't want a mandatory sentence, we want the judge to have discretion, and we give the judge discretion between a minimum and a maximum sentence? And isn't that what this body does? So that the judge that actually heard the facts can have that discretion?
You're exactly right. The question is someone has to decide, and the question is it better for this three-judge panel to decide or the judge who actually heard the case?
Thank you.
Representative Abdul Salam.
Yes, ma'am. Just wanted to ask you if you know, if not, we'll ask one of the others. How exactly are the three-judge panels chosen? How long do they sit? Are there terms? Or there three-judge panels in districts? I mean, I don't know how that's.
I can give you some general information, and then I'll let Judge Osborne, if he wants to address it, or one of the prosecutors address it with specific information. But it is a rotating panel. I think they sit either for a year or 6 months or something in that matter, and they're picked, I believe, by the Georgia Superior Court Judges Council on a rotating basis.
Okay. Thank you very much.
Representative Setzler. Further questions of the author? If you'd stand by with us, Mr. Whip.
Be happy to.
We had 2 people that had signed up on this one. Mr. McDade.
Mr. Chairman, members of the committee, my name is David McDade. I'm the district attorney in Douglas County. I'm also here as the representative for the 49 elected district attorneys on the District Attorney Association, and we appreciate the committee considering this bill. We want to thank Representative Fleming for bringing the bill. This was an issue that we raised with Representative Fleming. It is the #1 issue that DAs have asked this legislature to consider this year. What I would like to do first is respond to Representative Benfield's question. The decision was handed down by the Supreme Court on June 26 of 2006. You have it on page 10 of the decision is the language where the Supreme Court directs the trial court to look very carefully at the constitutionality question. What has happened in the past up until the time the Supreme Court got jurisdiction over this case was the lower courts continually found that DAs lacked standing to address this issue to an appellate court. We were finally successful in bringing this case to the Supreme Court. The Supreme Court clearly stated we have standing. We represent the people of the state of Georgia. We're elected to represent victims, and they conferred upon us unequivocally standing to raise these issues. In the decision by Justice Carley remaining the case back on page 10, his language is clear, and I'm going to read from the opinion. Whether that legislative grant of judicial authority is constitutional under the Separation of Powers Clause as well as the exclusivity clause of Article 6, Section 1 is an important question. He then goes on to caution the trial judge that originally denied us standing to address it. He cautioned that trial judge to look carefully at that issue because he believed that possibly the trial judge had somewhat overlooked it in the trial judge's haste to deny us standing. So he remains it back with his direction to look at the constitutionality of it and encourages the trial judge to look at it carefully in light of he has conferred and the Supreme Court has conferred standing on us. The reasons that the District Attorney Association believes that this panel has outlived its usefulness are as follows. In the early 70s, before this law was passed by the legislature, sentences were handed down by the juries. The juries actually set the number of years that they believed were appropriate within the guidelines that were set by the legislature. In the early 70s, that process changed to where judges were imposing the sentences. The judges would preside over the case, the jury would determine guilt or innocence, and then the judge would impose a sentence. Early on, there was a fear amongst judges that some of their brethren might be sentencing grotesquely disproportionately to what the rest of the state was doing. And the bill was created in its original form to address the possibility that, for instance, some of the examples that have been used, what a Fulton County judge sentenced a person the same way a judge in South Georgia might sentence. And Representative Fleming made the point that is the most critical point. We agree that someone should be determining what the appropriate sentence is. What we agree with Representative Fleming on is that it should be the judge that heard the case, that listened to the witnesses, that listened to the victims, that factored all of those considerations into the decision-making process that you have repeatedly said belongs with the trial judge. It is the trial judge's obligation to impose the sentence that is fair and just. And we believe, therefore, that by creating this three-judge panel that does not hear from the witnesses, does not hear from the victims, does not have an opportunity to examine the demeanor of witnesses, that doesn't have an opportunity to go back and listen to the testimony that was presented at trial, doesn't know the context in which information was developed, that three-judge panel simply replaces its opinion on a very limited view of whatever is presented to them. The reasons that the panel, we believe, the reason we believe that the panel needs to be abolished are as follows. There's no other creature in the legislative process or in the judicial process that permits secret hearings. These hearings by this panel are not conducted in public. They're not conducted on a set schedule. You never know when they're taking up your case. There is no announced calendar. There's no date and time, place set. We couldn't show up at a hearing where they were taking up a case and offer testimony anyway. The rules don't permit it. The judges meet whenever that group of judges decides to meet. However they choose to meet, we don't know. What that does is that prevents the public from knowing what's happening. It prevents the victim, who we represent, from appearing before a panel and letting that panel know how they feel about what's happened in the case. It is grotesquely unfair. It is not a recognized practice in any of the jurisprudence in Georgia now or in the federal system that I'm aware of. I don't believe there's any other creature like this anywhere else that allows this process to occur in secret. There's no record created. There is no right to review what they do. What happens is, a year or so after a case is sentenced, if the panel has granted some sort of reduction, I get a letter from the panel telling me they have reduced the sentence. Hopefully, before they did that, they sent me a letter telling me they were taking up the case. Hopefully, they sent me a letter telling me that the defendant or someone on his behalf had submitted an argument to them. That doesn't always occur. Sometimes what happens is I simply get a letter telling me this case has been reduced with no input whatsoever. And it's just wrong. We have a number of instances that we can share with you, and Joe Mulholland, the district attorney from South Georgia, will share with you the facts of the case that went to the Supreme Court. It's an egregious case, but there are many, many cases that involve negotiated pleas where sentences are being set aside by this panel, and we have no understanding or reason to take to our victims and explain to them why they reduced them.
Thank you, Mr. McDade. Questions of Mr. McDade from members of the committee? Representative Benfield.
Thank you for your statement, especially regarding allowing judges who've actually heard the case, heard from the witnesses, viewed the evidence to make decisions about sentencing. And maybe you'll join me in supporting me in doing away with mandatory minimum sentences in Georgia, because I think they unnecessarily tie judges' hands. My question, and you may not be the best person for this, is I recall during Governor Barnes's last year in office, he had a statewide commission to review sentence differences, and my recollection is that did not get funded because he was not reelected. Do you remember what happened with that commission? Because I like what he was trying to do with that, to study statewide inconsistencies in sentences.
My personal recollection was he created a blue ribbon panel, as he
That's
called it, and it was asked or tasked to look at other states and how they impose sentences. And I know that committee met, and I know they generated a report that no action was taken on. And it compared what Georgia does with other states, Michigan, South Carolina, and the sentencing schemes that were in place in those states. It was looking more at the range of punishment that was available and the parolability of those cases. The Michigan system, for instance, some people call it a non-parolable system, but the sentencing ranges are much smaller. But that's my recollection of what happened.
If I may have a follow-up, and I agree with a lot of the concerns that you have raised and that Representative Fleming has raised on the current process. I think it is flawed, but I hate to do away with that review, and so perhaps we could take a look at that blue ribbon task force and look at some of their recommendations, because I just have serious concerns about just doing away with the whole system without replacing it with something.
Thank you.
Further, Representative Levitas.
My understanding is that there is some kind of pilot project right now in 2 or 3 jurisdictions throughout the state that's dealing with alternative sentencing plans, although I know it's not exactly the same thing as a commission on uniformity. Is that your understanding? This, if I may, Mr. Chairman, is for anybody on the prosecution side that's familiar with it. I believe we had some testimony to that effect yesterday.
We have a number of attorneys here.
In fact, I think the person who testified to that may be standing up right now. Is that?
I'm not a district attorney. I'm the judge of the week here. I was just going to explain the pilot project that's in place now. This was worked out through the Department of Corrections, part in Borough as well. There are 4 circuits in the state, of 4 counties that are currently trying this. Floyd County, Slayton County, Bibb County, and Tift County. And the effort was to obtain a cross-section of urban, suburban, and rural areas of the state to try this. More sentencing alternatives have been made available there, day report centers, things of this nature. And the feedback that I have received from the judges is very favorable, because you can retain more control over defendants in a more strict environment with closer supervision that is not available around the state now, and it saves having to send so many people to prison. But it's working as well. The recidivism rates are down in those areas. It is still in the pilot project stage. I think it's gone on for about 2 years, and the results of that, I think, are supposed to be gathered after another year or 2. But it's going on now, and that was done in part as a result of the efforts by Governor Barnes just to bring out what some view as some inconsistency in sentences being handed out around the state. And a lot of that was a result of, a lack of sentencing alternatives. Some of these places to send people, there's drug treatment, more of that available, supervision to make sure they get jobs, curfews, and so forth. So that's the project that is ongoing now.
Mr. Chairman, there's one other point I would like to raise, if the chair would permit me, very briefly. If this panel, as it currently existed, had the authority to weigh comparative sentences around the state and adjust them upwards or downwards, I think it would have a little bit more credibility. The panel, as it's created, only has the authority to reduce a sentence. So it doesn't actually address the issue of inconsistent sentences, in that if it did, it should have had the authority to increase as well as decrease. So what happens is only one side of the spectrum ever gets addressed in any decisions they make. They don't have the authority to increase the sentence or raise it at all. And so if a sentence were deemed to be too light in comparison to others, which, believe it or not, does occur in our opinion, this panel doesn't have the authority to adjust it that way either. So another reason why we believe it's defective.
Representative Setzler.
You're talking about this being sort of without precedent anywhere else. Are there any other states that have this 3-judge panel that do this?
I'm not aware of any state that has a 3-judge panel that has the power that this panel has to conduct business in the manner in which it conducts business. Now, I could be corrected if someone knows of one, but we've looked at it and don't know of any.
So if we as a state were to not just look at this or study it or reduce it or tweak it, but we're completely remove it, we would simply be making ourselves as a state consistent with other states in the way their court systems run and the way these kinds of procedures.
That would be my belief.
So, and again, I asked the question because, you know, as you look at departing from the status quo, you're always careful about doing it, you're always thoughtful about doing it. But it would seem, as I understand this, that Georgia is somewhat of an outlier having this system, and this would make us more consistent with common practice.
Further questions of Mr. McDade? Representative Abdul Salam. Okay. Representative Everson.
Staff. There are others here that have more specific information, I'm certain, but the information that we have, it comes from the Council of Superior Court judges, but you can't identify it within their budget. But that's state funding.
Thank you.
Representative Abdul Salam.
Ms. McDade, what is the, I guess, currently statewide overview of sentencing? I mean, who has oversight now?
There are at least 3 entities that have oversight now. First and foremost, the parole board. Okay. The parole board has as its mandated function the obligation to look at the appropriateness of any sentence that's imposed when considering whether or not to release a person on parole that's been sentenced to a period of confinement. And that is their defined duty to do so. So that's the first entity that does it statewide. Both the appellate courts, the Court of Appeals and Supreme Court of Georgia, look at the appropriateness of any sentence that's under review before those courts. They look to the appropriateness of whether it fits within the guidelines that the legislature has set. And those entities review it as well.
Thank you. Follow up, Mr. Chair.
Sure.
So there's no mechanism. I guess I incorrectly, until listening to you all today, I incorrectly thought that once inmates were sentenced, that there was some automatic review of the sentence before they were sent off to prison, or soon thereafter. So that does not happen.
I'm not aware of a mechanism whereby it's automatically reviewed. Their sentence would be reviewed by the Department of Corrections. The parole board functions in the Department of Corrections when the paperwork is processed. Okay. But every defendant that's convicted has the right to an automatic appeal. They have a right to have an appeal. It's not an automatic appeal, but they have a right to have their case.
Well, I guess that's where I'm trying to go with it, is that unless you've got the money for the lawyers to do the appeals and appeals and appeals, and it would be helpful to have another set of objective 6 eyes, I think, take a look at it. I mean, I agree. The changes that you talk about or the flaws, I agree they need to be fixed. But I just think that it would be very disruptive, because some people really are put in too long and for, you know. But there's nobody other than this panel, I guess, that would actually look at that early on. The parole board probably won't even look at it until it's time for you to be paroled.
Let me respond to that this way. This panel is not charged with the responsibility of reviewing a sentence until and unless an appellate process has run its course, or, I'm talking about the panel. The panel doesn't necessarily even look at this sentence until much later in the process. A defendant can trigger the panel's ability to review it if he applies for it sooner, but he's not given an automatic review by this panel either.
Thank you.
Representative Everson.
Yes, Mr. Chairman, thank you. Just a point of clarification. In your brief statement a moment earlier, you stated that the panel does not have the authority to increase a sentence, but only to decrease a sentence.
That is correct.
That is correct.
Yes, sir.
Thank you.
Further questions of Mr. McDade? Thank you, Mr. McDade. Mr. Mulholland.
Thank you, Mr. Chairman. Good morning. I'm the District Attorney down South Georgia Circuit, Joe Mulholland.
I testified yesterday at the subcommittee, and I'm going to be very brief in my remarks. I would like to address a few things about the case at bar that is in my circuit, for which is actually on appeal in the Fulton Superior Courts that has brought this issue to the forefront. That particular case, the defendant was charged with murder, murdering her boyfriend after she was under the influence of drugs and alcohol. We pled the case at the conclusion of the case based on the fact that the victim's family wanted some kind of resolution. They wanted this case to be dealt with and done with, so they'd have some finality and could go on with their lives. We agreed to the lesser included offense of voluntary manslaughter. The sentence was 15 years to serve. The judge in that particular case followed the recommendation. The district attorney's office made that recommendation. The family was satisfied. Obviously, they weren't happy. They'd lost their father, their brother, their son, but they were satisfied with the resolution of that case being 15 years. The defendant agreed to that particular sentence, and the defense attorney agreed to that. The defendant pled guilty, and then a couple months later, the sentence is reduced from 15 years to 8 years. And that's the problem with this system as it stands. Not only is it impractical for these judges who have their own caseload to then take 3 months out of their time and review hundreds and hundreds of cases, it's impractical and it's unreliable. 1 year back in 1991, 113 cases were reduced out of the ones that were reviewed. But in 1996, 5 years later, 8. So you can't say that system brings any consistency whatsoever. I mean, the fact is these 3-judge panels act as at their own whim without any kind of checks and balances, which is what our system is based on. The judge at the trial level is able to look at the facts and circumstances in any particular case and decide that the sentence is appropriate. There was a question, I believe, as to what the sentence, whether or not there's any kind of review of that. These judges in this particular case that we have appealed didn't even have the transcripts of the plea. They didn't even have the facts and circumstances when they reduced it. They reduced it simply based on the fact that they got letters from the defendant's family, which is just egregious. I mean, they didn't even know anything about the case other than what they got from a letter. And that's what's wrong with this system. The judges in these particular cases are not in a position to fairly and accurately look at the facts and circumstances and make a determination as to what the sentence should be. And that's the problem with it. The parole board is. The fact is, if you get sentenced in Bainbridge, Georgia for 3 years to serve on a cocaine charge, and you get 6 months in Fulton County, you're going to get 6 months. You're actually going to serve 6 months through the parole board. They have guidelines that set forth how much time you're going to serve based on what the offense is. We already have that system. So this is basically cumulative and does a worse job of actually showing a consistent pattern as to what the sentence should be. And that's why we've appealed it to the Supreme Court. They said that we had standing. My predecessor actually prosecuted the case. I've been appealing it with him. The Supreme Court said that we did have standing. We are currently in Fulton Superior Court. I sent up a Rule Nisi 2 months ago. I have not heard back proposed order before that, and we're just sitting and waiting on the judge to make a ruling that we will take up because it's unconstitutional. I stated some statistics from 1991 and 1996, and I told the subcommittee this the other day. You can't find the statistics of how many cases have been overturned and reduced nowadays, nor can you find their budget. They used to include as part of their annual report how much money was spent and how many cases were particularly reduced in a year. That's not part of this anymore. This is a star chamber. They act at their own whim and discretion of that 3-judge panel, and it matters who you have on that 3-judge panel as to what the sentence is going to be reduced or not, and that's not right. We have a system in place that works with the parole board. We have a system in place that works with the appellate courts that can look at and see if there's actually something wrong with the sentence and reverse it based on a reversible error rather than writing letters from a defendant. And that's just not right. There has to be some finality in the system, and that is why we have in place the checks and balances we do. This particular board has no checks or balances. They don't have to give a reason as to why they've had a sentence reduced. They don't have to go and explain what their reasoning was as the Court of Appeals, as the Supreme Court does. And that's why we're asking this particular panel be repealed.
Questions for Mr. Mulholland from the committee? Representative Everson. Okay. No, I will not recognize you yet. Questions from the committee? Representative Lunsford.
It was a plea. We had compiled the case in 2002 at the beginning of the year. January was when she actually committed the offense. Later that year in the summer, we had the GBI investigation completed, went with the offer that the family was agreeable to, which was 15 years to serve. They pled guilty. It was a negotiated plea. Everybody signed off on it. We were all in agreement.
So actually, you guys were gathering information, working on this for 5, 6 months?
At least, yes, sir.
And you're saying the three-judge panel meets 3 months a year?
They meet for 3 months, 2 concurrent panels at the same time. Is that right, Judge Osborne?
If you look in the portion of the statute that has been stricken, it contains what the original statute provided, and the judges serve for a period, a term of 3 months until their successor's named. But all of that is in the portion that was struck. That's the old law that's contained in there. They serve for 3 months at a time, and we receive the boxes of the papers to go over and then meet in Atlanta later after we've gone over.
Judge Osborne, he's actually one of my judges and one of the nicest guys I know. Judge, how much time do you think that panel can actually spend on each case if you're just with the volume that they actually get in to look at review?
Well, we are appointed to do that by the president of the council in addition to our regular caseload, and when we receive them, we receive it's a pack of material. It has the original application. The district attorney's offered to have any comments. The defendants offered to have comments, and any other information that's gathered, and it's all stapled together as a package. And we probably would receive, say, 300 of those at a time. And we try to go over them, and I took mine home and spent a lot of time just going over them in the extra time. Then later, any that we want to review, when I say we, whoever's on the panel, this is according to the statute. This is the procedures that was provided there. We then, the cases that are to actually be reviewed, that if one person wants the files pulled, then they're reviewed and they actually meet in Atlanta, go over those, and anything in both whether to actually change them.
Let me ask you a question, Judge. When a panel gets notice, I guess, that you're to serve this 3-month period of time, is that sort of what you get?
You are notified that they want you to serve. They try to get some of the newer judges to do it, to have contact with cases from around the state, and you're not armed and made to serve, but you're asked, could you serve, say, October, November, and December in a particular year? And you say yes, and then probably in September or so you would receive the collection of the cases where application has been made. When an application is filed, it takes the clerk, and by the way, the council, we're taking no position on this, so I'm just answering your question, the mechanics of it. It takes the clerk 6 to 8 months or so sometimes to get everything together, to send it to our offices. Then we have to determine under the statute if it is a sentence that is eligible for review. It's got to be for 12 years or more. Not every sentence is eligible for. So it's 12 years or more. Then it's all gathered and it goes out, copied, and goes out to the people that are on the panel, and then the panel has it.
But when you get that notice, correct me if I'm wrong, my understanding is that you can decline to serve if you choose to.
Well, in theory, that's right.
Okay.
But we feel. I feel like that's a part of our duty. You don't have like a lot of prosecutors and others. You don't have a 9-to-5 job. That's part of being a Superior Court judge. It's in the law, and you're asked to do it. And I dare say there's not one in Georgia that has not been required to serve on it at some point.
Okay, thank you, sir. Further questions of Mr. Mulholland? Further questions?
Thank you, Mr. Chairman.
Thank you, Mr. Mulholland, and thank you, Judge, for helping us out on that. No one else had signed up to speak on this bill. Any questions? Any comments from the committee? Recognize Chairman Knox. You're recognized.
You pass as amended on page 3, line 29, changing that date November 1st, 2007 to November 1st, 2008. I guess that did turn itself.
Now, we're working, and I should have said this earlier, from 2800S. Correct? All right. State your proposed amendment or motion again.
Move that we do pass House Bill 197
version LC 2929S with the change at line 29 on page 3, change the date on that line from November 1st, 2007 to November 1st, 2008. I guess that would make this a committee sub then.
Mm-hmm. Okay, you've heard the motion.
Second.
Motion is seconded by Vice Chairman Mumford. We have a motion that we give House Bill 197 a do-pass recommendation by committee sub, which would include the amendment proposed by Chairman Knox. Is there any discussion on the motion? Any discussion on the motion? All in favor of the motion, please indicate by raising your right hand. Okay, thank you. All opposed, indicate by raising your hand. The motion has been approved and will be reported to the Rules Committee favorably. Thank you, Representative Fleming.
Thank you, Mr. Chairman.